It's 9:30 on Wednesday, the 10th of September, and it's day 7 of the proposed Hill of Fare wind farm inquiry. We're going to finish this morning with the policy hearing session that we began yesterday. There's a few policy issues still to discuss, and we're then going to have the conditions hearing session. We are fully expecting of finishing both of those today, and then that will bring the public inquiry sessions to an overall close. So yesterday I had skipped a little bit on the agenda, so I think where we can sensibly start today is on top of page 3 with policy 11 on energy. I've picked out here a few aspects of that policy that seemed to come out to me from the submissions as being the elements where there was a bit of debate over interpretation as opposed to merits. So I just propose to run through those. There's one I want to add in, which is policy 11E5, impacts on telecommunications. I just want to have a brief discussion on whether we need to be looking at applying VAT in respect of the Meikle tap mast, which was discussed at the community hearing session and in some submissions. So I'll start with the first question there, which is about net economic impact. On the evidence before the inquiry, how should the ministers address whether the proposed development meets the requirements of NPF 4 policy 11C? And it makes sense, I think, to run that together with looking at the Aberdeenshire Council Wealth Building Strategy and Aberdeenshire Council Wealth Building Energy Development Charter, which under section 6 on the LDP, I've got a question there on how I should consider those documents when I'm interpreting and applying NPF 4 policy 11C. So I'll start with the applicant on this issue, please.
Thank you, ma'am. Good morning. I think your question asks how should the ministers address whether it meets the requirements. I would say they should follow the approach that they've taken in all of the, I think it's 37, section 36 wind farm decisions post NPF 4 that have been made by the Scottish ministers. I think the number is 37. And before coming to their position that they've set out a number of times, one document that the applicant lodged in my hearing statement at section 2.7, there's the Green Industrial Strategy, which is the latest Scottish Government industrial strategy for the green economy. It's document 009.007, and it states that in the executive summary, the Green Industrial Strategy's mission is to ensure that Scotland realises the maximum possible economic benefit from the opportunities created by the transition to net zero. And that section of my hearing statement sets out a number of quotes, and there's a specific section on onshore wind, page 21, where it states the onshore wind workforce is highly skilled and opportunities, installation, consulting, operations and maintenance are anticipated to rise in response to growth ambitions. And we talked yesterday about the growth ambitions, the scale of that. The applicant has prepared a socio-economic appraisal. That's the appendix in the planning statement by NKA Economics. And I've summarised the key headline benefits in chapter 3 of my hearing statement for convenience of getting those. So the project benefits have been set out. In all of the Scottish Ministers' decisions, they have referred to that type of information, i.e. anticipated employment generation, capital spend, GVA figures, and so on for construction and operational phases. And just to give you a typical example, one of the relatively recent onshore wind decisions that is before the inquiry is called Crathaic. I think that's the pronunciation. It's document 013.009. and that's a Section 36 decision, paragraph 86. The Ministers state, whilst the overall net economic benefits are estimations of the effect of the development, the Ministers are satisfied that the development has the potential for positive net economic benefits for local communities of Argyll and Bute and for Scotland. And then they go on at paragraph 81 to say decisions should be guided by policy principles including, amongst other things, giving due weight to net economic benefit, supporting the delivery of energy infrastructure, reducing greenhouse gas emissions and responding to the nature crisis. So they put the economic aspect in the mix with all the other benefits, which accords with reading NPF 4 as a whole. So the applicant's position is that that would be the approach to take. Information has been provided which demonstrates the estimations, and it can only ever be estimations, of the likely economic benefit. And that's set within the national context of what the ministers are trying to achieve within the sector and the green economy. Would you like me to go on to the other aspect of wealth building, or pause there? Just to...
I was just going to mention something, which is that we did have an exchange of further written submissions on this topic then, and I think the overall, well, part of the message from the applicant was that the socio-economic part of the EIAR needed to be read alongside that socio-economic appraisal in the policy statement that you'd mentioned just now. You might not.
So I didn't quite hear you exactly there.
I was just flagging that we had an exchange of further written submissions on socio-economic benefits, yes. And the applicant said in its response to that, as you've said, there's a socio-economic appraisal in the policy submission, yep, which should be read alongside the EIAR socio-economic chapter.
That's right.
Yeah.
That's right.
So we've got
I think
that.
all I would say on the Council's wealth building strategy fits with the applicant's approach, namely the applicant's approach would further advance a number of the aspects of the Council's wealth building strategy. Some of that does venture into community benefits, and therefore there's some questions over materiality. But insofar as there are socio-economic benefits locally and other direct community benefits, these have been set out, and it can be seen how they align with what the Council was trying to achieve, I think. Thank you.
Thank you. And could I hear from the Council?
Thank you, ma'am. The starting point for the Council when looking at 11C is really considering what is meant by maximisation of net economic benefit. In our assessment of the application, we probably approached it in quite a similar manner to the applicant, in the expectation that the socio-economic chapter of the EIA is quite foundational to identifying the impact of the development. But where the policy does fall short is that there is no definition of what maximisation of the net economic benefit is. In picking up on the point around how ministers have addressed this in other decisions, there's maybe a distinction to be drawn between a demonstrable positive economic impact and the maximisation of the economic impact. It's a tricky line to tread due to the lack of guidance in relation to this. As a council, we have approached it by advising, or as a planning service, we advised our members that they should place no weight positively or negatively in relation to 11C, because there is a lack of guidance and a lack of means of securing the measures that are identified. They often fall out with the scope of planning conditions, for example, and that's a further limiting factor. In terms of our community wealth building, or our charter that we have developed, this is a more recent production by the council, and I will just be clear that we are not seeking to object to the development on a new grounds. We need to be mindful of the point at which this was adopted in relation to the application, but it has been put before the inquiry as it outlines the council's priorities in terms of maximisation of economic benefit and community wealth building. We're trying to take a longer term and more strategic approach to this. It's not simply about the jobs that are necessarily created by a development occurring, but it's also about building capacity within the communities, building skills within the communities, and empowering or improving the economic basis of Aberdeenshire. The approach that the Council is taking on large-scale energy developments more recently, and this has really only been in the past couple of weeks, which is why we've not perhaps flagged it as part of our submissions, but we are starting to attach conditions to large-scale infrastructure developments, asking developers to monitor the impact of the development against the indicators that they have identified within their EIA, for example. This would be on an annual basis during the construction, and perhaps for a couple of years afterwards, to detail, for example, how many jobs have they created, how many are local to Aberdeenshire, what has the supply chain impact been, and the purpose of that approach is to provide an evidence base to the Council moving forward so that we are better placed to address issues relating to 11C and Policy 25 as things move forward. But I suppose to take it back to the original purpose of the question, I think we need to be mindful of the weight that we can apply to 11C. However desirable the policy is to implement, it's quite difficult to manage under the current planning regime.
Perhaps I could add to that, accept what Mr. Bell said about previous decisions, but none of them, as far as I'm aware, grapple with the idea of maximising net economic benefit. And really, they don't give any assistance as to that. And as Mr. Hewitt has just said, there's no guidance on that. And the pragmatic approach the Council has taken, which Mr. Hewitt has outlined, is in effect accords with that which Mr. Bell has indicated. But that doesn't get away from the point that it's perhaps unlikely that there has been demonstrated that the proposal maximises what it's meant to maximise, but for the reasons Mr. Hewitt has given, the Council doesn't suggest that particular weight should be given for or against that in any extent.
Thank you. And who would like to speak for Hoffwig?
Good morning. You asked a question. How should ministers address whether the proposed development meets the terms of the policy? That means you have to look at the policy and actually understand what it says and try and understand what it means. It's a conditional policy. It says support will only be given where it's demonstrated that net economic impact is maximised. And it's in two parts. It includes that generality plus local and community socio-economic benefits such as employment, associated business and supply chain opportunities. The EIAR is quite clear that there will be no meaningful local economic benefit from this development. That's out of the mouths of the developers themselves. With greatest respect, Mr. Bell has missed the point, because what he has done in his usual eloquent way is to focus on potential as it is exemplified by, for example, the Green Industrial Strategy. But Scottish ministers are not able to assess potential unless an applicant comes forward with some form of idea as to how economic benefit is to spread out from this development. Mr. Bell has talked in generalised policy terms about motherhood and apple pie, as seen in the by the Scottish ministers. What they would like to see, that's all very well. That's not the same as maximisation. So, with respect to Mr. Bell, he's missed the point. I also join with my own friend Mr. Finlay in looking at those decisions. They haven't grappled with the idea of what maximisation means. Now, if you're coming to this policy as case number 38, you're going to ask the question that you've asked us to try and answer. And if I may respectfully suggest, your answer should be that the developer has not demonstrated how it will maximise net economic benefit, and therefore it is impossible for ministers to support this application, because this policy has simply failed. Mr Chesterton's got something to add, I think. Briefly, please.
Yeah. Good morning, ma'am. First, a small observation that Mr Bell mentions industrial strategy, and yet the turbines on the top of the hill are not industrial, they assert. I think the concerns with this are that, as with claims that the proposal will power 100,000 homes, which turns out to be fictional, the developer tries to show the economics in the most possible flattering light, although, as John said, in the application it says that the economic benefit is minimal. But they have elsewhere reported net on economic impact of 150 million for the local area based on a 50-year lifespan. No other wind farms in Scotland are based on a 50-year lifespan, and no evidence is brought to justify that. As presented by Hofwig in our submission, there is very little evidence that this proposal will bring economic benefit to Deeside or to Aberdeenshire for policy 11C. It brings construction jobs, but very few local jobs. So we believe that the small amount of local revenue brought to local contractors and hospitality businesses, but the long-term fiscal arrangements are poor for Scotland and for Aberdeenshire. Thank you.
Thank you, Alan.
Thank you very much. Has anybody got any additional?
I'll just make a very quick point of view, Wood, please. In this particular development, I think you've heard that there is quite a lot of uncertainty regarding the net economic benefits because of its prominence with the ensuing risks to tourism and Scotland's brand that I was outlining yesterday. Therefore, I think caution on the real benefits would be a useful byword.
Thank you. And did anybody else want to come back in?
Thank you, ma'am. Just in response, just to correct Mr Chesterman, 50-year consents are have been granted by the Scottish ministers. Just to give you two, for example, Canny Extension and more recently Holland May and Caithness. So these are just two examples. In terms of the Council's position on potentially seeking to impose conditions to monitor the estimations in the EI report, the applicant would not accept such a condition and it would, in our view, fail the tests in the circular 498. We gave an example in my hearing statement where Highland Council sought to attach similar type conditions, for example, in the Bunloin decision letter, which is 013.010. The Minister has made the point that the EIA sets out very much estimations of potential impact, and it wouldn't be appropriate to seek to hold the developer exactly to those and then seek some form of compensation or redress if they were not met. The point about no meaningful economic benefit, that is simply not accepted. The figures are set out, and indeed the Scottish ministers have, on similar scales of development, have set out their position that there would be positive net economic benefit. I think if there is criticism of the applicant, then no party has sought to set out what the applicant needs to do to maximise net economic benefit. It is fully accepted that there is no guidance, and that has indeed been a gap that practitioners, councils and applicants have had to grapple with. But what we can do is look back at the way decision makers have dealt with the matter, and there is a consistency there that we can be assured on, I would say, is the right approach to take in this case. Thank you.
Can I just ask the Council to clarify? So I didn't understand it to be that you weren't proposing a condition in this case on the monitoring, were you?
Thank you, ma'am. It was raised as to, I suppose, inform that that is the approach that we are promoting on energy developments and infrastructure developments. It's not proposed necessarily in this case, but to pick up on the point that Mr. Bell has made, comparing it to the Highland Council conditions, the condition we would be seeking to attach to these kinds of developments is not necessarily about securing the measures as proposed. It is simply asking developers to report back on the impact of their developments. There's a distinction there. We are aware of that particular decision in Highland.
Okay, thank you very much for that. I'll move on to...
Perhaps I can just add to that. I think Mr. Bell overstates the decision in Highland on Bun Line. There is significant case law from England which suggests that conditions attaching requiring local economic benefit can be imposed if properly drafted. I'm not sure those conditions were the ones that were put forward in Bun Line, but you can have conditions which do seek to implement, at least in part, local economic impact. But I'm not sure that that's a matter. Well, it's certainly, as Mr. Hewitt's confirmed, it's not a matter we are seeking in this case.
Thank you very much. I'll move on to the next aspect of Policy 11, which is a question on how one considers any interaction between Policy 11E, which covers a range of matters, and other NPF policies where similar subject matter is referred to. I've given an example of the interaction between Policy 11E7 and Policy 7, which are on cultural heritage, historic environment. We touched on this a bit yesterday, I think, when we were talking about the interaction between Policy 11 and Policy 4A. Do parties have views on this? And I'll start with the applicant again.
Thank you. I think there seems to be general agreement first that Policy 11 is the lead policy, but there are then a number of other policies which are engaged through the topics that are at play for the development. For example, cultural heritage, Policy 7 provides a lens to look at the cultural heritage matters in more detail. In terms of the local landscape area, be Policy 4D, and so on. So that is the approach, is to look at the lead policy and then other relevant policies, and of course read NPF4 as a whole. That would be what I would recommend as the approach to the interaction. Thank you.
Thank you. The Council?
Thank you, ma'am. I think we would be largely in agreement with that approach, although when applying it, it's bearing in mind that the framing of 11E is centering around whether project design and mitigation are demonstrating whether the impacts have been addressed. The individual policies are generally useful when we're considering the acceptability of, I suppose, any design or mitigation, but that is the framing within 11E, and that's where emphasis should be placed.
Hez?
Yep, HES considers that for Policy 7 and Policy 11E7, they should align with one another. So if you were to find that the application doesn't meet the tests in Policy 7, then it would also not meet the test in Policy 11E7. This is the approach that's been taken previously in other decisions. For example, the Sheer Drim renewable energy development and the Lethen wind farm application, and that information is in my hearing report. But specifically, the reporters for the Sheer Drim application found that the proposal would not comply with Policy 11E7 due to the significant adverse impacts on the setting of the scheduled monument, which couldn't be avoided or minimised, and they concluded that no measures of design or mitigation addressed the impacts as required by Clause 7 of Policy 11E.
Mr. Campbell?
Thank you. We do agree with Mr. Bell that this is the lead policy. and obviously it's the place you'll go first. You will find some interaction, for example, as Ms Clements has said, with Policy 7. I would ask you to remember that an overarching theme of this policy framework is the just transition from fossil fuel to renewable energy. And therefore, if either of those policies which interact offer you an opportunity for what appears to be a just transition rather than a harsh transition, that's the route you should take. I don't think I want to speculate further at the moment, but just keep in mind the overarching idea of a just transition.
Okay, thank you very much. So my next question on policy 11 is, on the basis of the evidence that's before this inquiry, should the reporter regard the landscape and visual effects of the proposed development to be localised in terms of policy 11E2? And I'll start with the applicant again.
Thank you. The answer is, the short answer is yes. Just a detailed explanation on that is needed. I would say, firstly, the policy recognises that there will be some significant landscape and visual impacts there to be expected for some forms of renewable energy, and that's an inevitability with regard to onshore wind at a commercial scale. It says, as we know, where impacts are localised and or appropriate design mitigation has been applied, they will generally be considered to be acceptable. So I think the word generally is important, and that indicates that there may be occasions where localised impacts may not be acceptable. I think that was set out by the reporter in the Glendy decision. It was quite a helpful observation. In my view, though, these would generally be exceptions to the rule. So normally, localised impacts would be acceptable, but clearly subject to a given case. The applicant has set out its landscape evidence. You've heard that from Mr Ferber, and I think the key figures were that in terms of landscape character, significant effects extending out to around 6 kilometres, and visual significant effects out to around 10 kilometres. So that is the spatial extent. And in my view, that is the approach to considering whether landscape or visual effects are localised. It's the spatial extent. But there's then a need to look at receptors. But before we just depart from the spatial extent, I think it's helpful to look at two decisions. We don't need to go to them, but in my evidence I've referred to Cleanside, which is 013.011, which was 16 turbines at 200 metres to tip, where the ministers took the view that the effects out to 12 kilometres, landscape and visual, were deemed to be relatively localised. And Bunloin, that we've referred to this morning already, which is decision 013.010, 10 turbines at 200 metres, where the ministers considered the effects would be largely localised out to 12 kilometres and none extending beyond 14.7 as significant effects. So I think that gives us a useful guide in terms of the spatial extent of localisation. It's a geographical concept. But I think it's important then to look at the receptors that are affected within that area. Are there any sensitivities that would give rise to a position that the effects, notwithstanding that they are localised, would not be acceptable? And that will clearly vary in a given case. So I think in the Glendy example, I think the reporter considered that there was a regional hill that was within the localised extent of effects, but she deemed that that was not an impact that would be unacceptable. But it's an example of looking at receptors within a localised area. I think when looking at the provision in NPF 4, it's important again to look at the onshore wind policy statement. We covered that yesterday when it was published at the same time, and it has a section 3.6 which relates to NPF4 and landscape matters. It talks about the target of 20 gigawatts. It specifically refers to the requirement that there will be taller turbines, more efficient turbines. It states in underlined text this will change the landscape. There was also reference to an area's full potential being exploited appropriately, and we have the guidance in NPF4 that beyond national parks and national scenic areas, there is a position of support. That is the broad spatial planning approach, support in principle, subject to the criteria in NPF4 Policy 11, and as Mr Hewitt says, appropriate design mitigation comes into that as well. The other aspect in the onshore wind statement is the reference to stronger weight to the contribution of development, and that, in my view, has to change the calibration of where development would or would not be acceptable in the NPF4 context. So hopefully that's helpful. There's the geographical extent, and then there's looking at the particular receptors that are affected in review. Thank you.
So, just to add to that, I think in fact distances for significant effects are broadly 7 but out to 10 for landscape and 11 for visual. That's what I think has come out of the evidence. It's broadly 7 for landscape, but the area down at the mouth takes that to 10 and 11 for visual.
And I think I'll come to Hothwick next and then the council. Yeah.
Mr Bell's doing a bit of injury to the Oxford English Dictionary, I think, when he looks at the way in which we should construe the word localise. But strangely, I found myself in agreement with him in his emphasis on geographical extent and receptors. And by applying common sense to this, local means local effect. You can't sit there and say local effects are bigger or greater in Bankery because they happen to be bigger or greater in the wilds of Westeros or wherever those decisions are. And Mr Briggs will deal with this point, but I urge you again just to take care with the way in which you read the language and what it actually means. Mr Briggs.
I covered this ground yesterday to a considerable degree, and arguments as to what should be localised, both from a geographical extent perspective, and I mentioned the ZTVs as being a useful vehicle for comparison. So if this, it's important to ensure consistency in the consenting process between developments in the same area and region, which was why I focused on Mid-Hill, Fetteresso and Glen-Dye. And I gave some numbers and I gave examples of the ZTV, how very different they were. And that's purely on the geographical extent. Mr Bell has mentioned in Glen-Dye that there are substantial effects in a local area, and there are, but they're well within 5 kilometres. And that's it. It's the users of the hills, in particular Clacton-y-Ben, which is nearby, which would be severely impacted. And the reporter in that case accepted that that was acceptable. But what I'm talking about is a much bigger area. We've talked about going out to 7-10 kilometres. Now, in Glen-Dye, that is very different. There is nothing out there. It's screened by the various hills, as I demonstrated. Hill of Fare is completely different. It's most of the area within 10 kilometres. It is possible to see the turbines, accepting that local trees, buildings, etc., and local topography makes it. There would certainly be areas where it's not possible to see, but in general, it is because of its prominence. It would be possible to see the Hill of Fare for most of the area around. People have talked about 360 degrees. So it's a completely different thing from Federesso and Glendy to Hill of Fare. That's on the geographical extent. The other factor that Mr. Bell mentioned was receptors. And there again, we're talking chalk and cheese, basically. In my little table and in my precognition yesterday, I mentioned the number of people around Glendy, that live around Glendy, within 3 kilometres. It's 0. and it's obviously a lot more around Hill of Fare. And you've heard figures of 10,000 people, etc., etc. So clearly, in the terms of number of receptors, again, it's very, very different.
Yeah, sorry, I was just going to interrupt because you covered that in quite a lot of detail yesterday, but it sounds like you're not in disagreement on the approach of considering the geographical extent, but then looking closely at the receptors. But, obviously, and then I've got your evidence on what you think on both of those points. But in terms of that geographic extent and receptors being important considerations, are you broadly in agreement with that?
Yes, those are the two key factors. I agree. Yes.
Come to the council, please.
Thank you, ma'am. The short answer to your question, ma'am, for the council is no. There's potentially quite a lot to say on this topic, and it will be covered in written submissions, and I obviously don't want to stray into submissions and evidence this morning, ma'am. But the council's position on this is that the focus should be on the extent and the number of adverse effects on the landscape and visual receptors, and that the test should not be confined just to a spatial test. One of the points which may be quite helpful to clarify through yourself, ma'am, with Mr. Bell is whether he is advocating a particular distance in all cases, or a particular spatial extent in all cases.
Mr. Bell?
No, I'm not saying it's got to be 12 or got to be 13. There's a variety of distances, but we're dealing with tip heights generally of 200 metres, and those are 2 examples of 200 metre tip heights. So it's a helpful comparison. I wouldn't go into any of the facts and circumstances of the case beyond that. I think it gives us a useful broad guide as to the extent of significant effects, which will clearly vary in each case, as this one has shown. That's as far as I would take it. But I think the point of consistency in decision making has been made a few times, and I think it's helpful to see that what ministers, who will be the ultimate decision maker in this case, have taken as what is localised and what is not.
Thank you, that's helpful. Mr. Bell relies upon Cleanside and Bunloin decisions, and there are a couple of observations I would make on those this morning. First of all, those were applications which were not objected to, so the ministers didn't have the benefit of the sort of debate which is taking place in the context of this inquiry. And of course, the council, as has been previously indicated, relies upon the decision in Fosside and the inquiry report in Fosside, which was the subject of an inquiry and debate. The council also makes the point that looking at the decisions in Bunloin and Cleanside and looking at the maps which have been lodged by Hofwig, ma'am, it's clear that the significance of the effects were entirely different compared to the present. case. You only have to compare the maps. I think the Hofwig document number is 016.037. You only have to compare those with the EIAR figure 1, which is for the site location here, which is document 001-023. And just by comparing those maps, it's quite clear there is a much more significant effect here than there was even in Cleanside and Bunloin. Turning to the Fosside decision, ma'am, which is 016-006, and in particular internal page 121, paragraph 9.21. I don't need to take you to it at the moment, ma'am. It will be covered in submissions, but the point was made there by the reporter that distance is too simplistic and that a fine-grained approach is more appropriate if such impacts as occur are to be properly understood in their local context. And what the reporter does there, having made that general point, is proceeds to consider the particular impacts of that proposal. And even at that, ma'am, again, looking at the site location plans and maps and the ZTV for that development, the impacts, I would submit, were not as severe even in that case as they are in this case. The ZTVs are still available, ma'am, and they can be lodged if that would be of assistance in your deliberations. So the reporter in that case advocated a fine-grained test. And of course, when it comes to the fine-grained test, in this particular case, I'll not go into the detail of it, but we obviously have adverse effects on a significant number of viewpoints. We have adverse effects on a significant number of settlements. There are adverse effects on the local roads. There are adverse effects on the core paths and on the cycle routes in the vicinity. We also have, in this particular case, which has already been discussed this morning, a 360-degree effect. And again, the EIAR site location plan brings that home, that Hill of Fair sits in the middle of a populated area. And of course, there is Carol Anderson's point, which she made in her evidence, that she has never previously encountered a wind farm quite like this. In terms of Mr. Bell's point about the onshore wind policy statement in paragraph 3.6, which says that the landscape will change, I would make the point, ma'am, of course, that yes, the landscape will change, but it has to change in an acceptable way. And this particular proposal is not acceptable.
Could I just add to that, and just to come back to your point that you were putting to Hofwig about whether spatial extent is part of the test. I think one's got to be very careful about whether one, in terms of spatial extent, you're looking at extent of coverage in a 360-degree format, as Mr. Brown was alluding to, or just comparing distances, which appeared to be Mr. Bell's approach. In our view, if spatial extent is taking a 360-degree finer grain approach, looking at receptors, then that's acceptable. If it's simply looking at distances, it's not. And in the words of the inspector in Foresight, that is simplistic. Whilst it will be in our closing submissions, in Bunloin, which rather backs up, I think, Mr. Briggs's point, the significant landscape impacts only extended to 2 to 2.5 kilometres, compared to 7 to 10 in this case. And in Cleanside, they extended to 5 kilometres with the same comparison. It's another way of looking at the same issue as to whether they're comparators. But for the reasons given far more eloquently by Mr. Brown, our position is as he's stated, subject to that caveat, not caveat, but rider as to what spatial extent means.
Thank you, ma'am. I think the council is misunderstanding the approach that I set out. It's not a simplistic one of simply looking at distances. That is one of two steps. The second step is to follow exactly what Mr. Brown has set out. It's a fine-grained review of the receptors within the area that would be affected, localised or not, to then make a planning judgment informed by the policy framework on acceptability of impacts. And I think the Council seems to be dismissive of the Scottish Minister's decisions in Cleanside and Bunloin. These were informed by Nature Scott's stance, but also the Highland Council officers who are highly experienced at dealing with probably the most experienced planning authority in Scotland of dealing with large-scale wind farms and NPF4 policy application. So just wanted to make those points. Thank you.
Can I come back to that? Make it absolutely clear, we're not dismissive of Scottish Minister's decisions in Bunloin and Cleansay. What we are is dismissive of Mr Bell's attempted use of them out of context. He's quite right to point out that Highland Council didn't suggest in either case that the impacts were more than localised, but that was for the reasons they gave there. Our concern was that his attempt to use those by reference to distance alone was inappropriate. There's no suggestion that we're attacking the actual decisions in Bunloin or Cleanside, or that the approach in those is wrong. But as Mr Brown indicated, the issue wasn't debated fully as it was in Forsyth. But it would appear that there is agreement between us and the applicant as to the approach set out in Forsyth. So it may be that whether we're dismissive or not of Scottish Minister's other decisions is not particularly relevant.
Just to reiterate, Ma'am, very shortly, I'm not advocating use of distances alone. That was very clear and it's set out in my hearing statement. Thank you.
Oh, Mr Briggs.
Just very quickly, we've talked about Bunloin and Cleansay. So in that decision letter, it was mentioned that, and Mr Brown has already mentioned this, neither planning authority objected to those two. But in Cleansay, the planning authority did say this limited visibility is somewhat unexpected for a development of this scale. And again, it emphasises the clever placement of the turbines below a ridge, not on a ridge. And the local authority is happy to go with it. So, anyway.
I understand that a planning condition has been passed to you this morning, which provides an appropriate approach to dealing with that. I don't have any more information, but there is a way of dealing with it by way of condition.
Putting a bit of flesh on that, ma'am, we've established that, yes, there is a solution which will be talked about in the condition session, not here, I think, and a condition has been drafted accordingly and sent overnight to Hofwig and to other parties.
Yes, this is a matter that's been known to the applicants for about 3 years. Late last night, a draft condition, which is inadequate, came to me. I have had the opportunity to consult with the owner of the mast, who makes the very real point that there's no point in any condition being to the satisfaction of the planning authority, because it's not their mast. He is dependent on the mast for the operation of his business, and so if any approval has to be given, it should be by him and not by the planning authority. His whole business depends on this mast and on reliable communications. What it does is it fills in mobile phone gaps for the vehicles that he operates in his business, and so he's able to communicate with the drivers and the operators. So when we get to the condition section, I'll have more to say about this. Perhaps I'll just leave it at that at the moment.
Okay, so
If that answers your question, does it? I think so.
Yeah, so it sounds like we're agreeing this is applicable and we'll discuss it in conditions. Does anybody else?
That's correct, yes.
Paragraph that comes after the list of specific impacts to be considered under policy 11E. The paragraph is, in considering these impacts, significant weight will be placed on the contribution of the proposal to renewable energy generation targets and on greenhouse gas emissions reduction targets. And the two questions that I've posed in relation to that are, firstly, whether that requirement to place significant weight overrides other policies, and how I or the ministers should balance that significant weight requirement against any findings in relation to adverse effects. I'll start with the applicant.
Thank you, ma'am. I think the first point would be that it doesn't override other policies. That's the applicant's position. But when you take policy 1 and 11 together in terms of the direction to apply significant weight, and that's to targets, and we've looked at the wider energy policy framework relating to targets, then that is a forceful consideration that carries weight in the balance of considerations. And within that, there's a planning judgment to be made in relation to the impacts and the benefits, recognising also that this is national development and reading NPF4 as a whole. So that's as far as I would probably take it now as an approach, rather than going into the specifics of topic impacts and so on.
And the council?
Thank you, ma'am. Quite simply, no, the wording doesn't mean that the contributions to climate change and reduction in greenhouse gases outweighs any other consideration. The weight that you afford to various matters within the planning balance will be a matter of professional judgment, but it should be guided by the nature and significance of the effects that have been identified. So, for example, the significance of effect identified by Historic Environment Scotland in relation to the historic environment, or the nature of the landscape and visual effects and the evidence that you've heard, would suggest that those should also be afforded significant weight within that balancing exercise, and that the contributions of the development are not elevated above that. You can have multiple significant multiple items that you're attaching significant weight to within that balance.
Thank you. And Hez?
No, we would agree that MPF4 makes it clear that the document's to be read as a whole, and that although significant weight should be given, it's not that all of the considerations should be overridden. The reporters for the Shade Rim Renewable Energy Developments considered these matters in their supplementary report, They found that the climate emergency and increased renewable energy targets are integrated into the decision-making framework in NPF4. And whilst acknowledging the weighting of Policy 11 in support of renewable energy technologies, they noted that it does not give an automatic bypass of the impact on nationally protected historic assets. At paragraph 2.102, they identified that the significant weight in Policy 1 and Policy 11 is largely due to the strategic objectives that would be met, but that these do not alter that it would fail to address the significant adverse impacts that it would bring on the integrity of the setting of the scheduled monument. And in paragraph 3.9, they state that although Policy 1 and Policy 11 give the proposal significant weight, at no point does NPF4 or other national policy state that these factors automatically override the legal protection of nationally important scheduled monuments or the policy protection of the integrity of their settings. And then again at paragraph 3.12, they confirmed that despite the significant weight assigned by NPF4 to the proposal and its status as national development, those things do not make this proposal automatically acceptable. Neither of those factors meant that the significant adverse impacts on the setting of the scheduled monument should be accepted. The Scottish Minister's decision letter for Sheardrim confirmed on pages 16, 17 and 19 that the policies within NPF4 require to be read as a whole and considered and balanced when reaching a decision on applications for wind energy development, and even taking into account the significant support assigned by NPF4 to the proposed development and its status as national development. This ultimately leads the Scottish Ministers to the conclusion that despite the many factors in favour, this is not the right development in the right place, and the proposed development is therefore not acceptable overall. And that approach was confirmed in the Scottish Minister's decision for the Lethen wind farm application. Page 19 of that decision, the Scottish Minister stated that although Policy 11 requires that in considering impacts from the development that significant weight will be placed on the contribution to renewable energy generation targets and greenhouse emission reduction targets, the policies within NPF4 required to be read as a whole and considered and balanced when reaching a decision on wind energy development.
Thank you very much. And Hoffwig.
So we agree with Mr. Bell and Mr. Hewitt that the one consideration shouldn't override another, and that the benefits need to be significant to outweigh the significant impacts. We believe those benefits should be assessed on what is realistic. The applicant's carbon calculations are deeply flawed and greatly overestimate the contribution towards GHG emissions.
Okay, I'll take your evidence on impacts from the wider evidence. You don't need to give examples.
We also believe that NPF Policy 2 requirements are not being met in regard to minimising life cycle emissions by selecting a site that is built on peatland and therefore will cause a very large carbon deficit or footprint.
Thank you, Mr. Briggs.
If I could just build on that, please. You don't want details of the carbon calculation, that's fine. They're all in the Hoffwig policy report, 016.004.
And there's further written submissions on it too.
Yep. However, what is not in there is something that backs up everything that we've put in that submission. And I'm afraid we only found this last week, and you may not be aware of it. It's the carbon calculator for wind farms on Scottish peatlands, an evidence assessment, and this was done.
I can't introduce new evidence.
Can I just quote from this, because it's a government...
No, if it's not before the inquiry, I can't, because other people haven't been cited on it, and it's not fair.
Okay, can I then just leave it with you that this backs up exactly what we have put in those calculations? And can I leave you with the thought that the underlying issue here is how will wind farms repay the carbon used or created in their construction when we are very close to and indeed have met net zero for our power generation? This is an issue that has not been addressed, but our work in that submission starts to address it. And I know this is not permitted, but it is there and it says the same thing.
Thank you, and I've got your evidence on carbon calculator and peat. There's a lot of evidence before the inquiry on aspects of that.
Maybe one point that might assist just on that matter to conclude it. In NPF4, and I appreciate Mr Briggs is maybe not that familiar with NPF4 in its detail, but under National Development 3, in my version it's page 103, there's a life cycle greenhouse gas emissions assessment that has been undertaken by the Scottish Government for all National Development 3, and it states that the assessment concludes that this development will likely have an overall net positive impact on achieving national greenhouse gas emissions reduction targets. So the government's assessed this land use type and takes the view that it will have a net positive impact, and of course that aligns with the Climate Change Committee's view that we explored yesterday on the need for clean power to address emissions and reduce carbon. Thank you.
Yes, but for completeness, we should be looking at the Climate Change Committee's observations and Clean Power 2030. And then draw your attention to the table 7, which sets out the up-to-date figures.
Ma'am, I might add something. A net positive benefit is not necessarily a significant contribution to CO2 reduction.
Okay, thank you very much. So I'm going to...
Excuse me, sorry, I just want to re-emphasise that Halfig would actually support the comments made by Aberdeenshire Council and also by HES. And I just, in answer to the question that you were raising, I just really want to re-emphasise again that this is a national development and the National Spatial Strategy is relevant to this proposal. And I think we've all agreed that all the policies need to be read in NPF4 as one. And I think there's further clarification within NPF4 on page 7 under the National Spatial Strategy that actually confirms that whilst meeting our climate ambition will require a rapid transformation, it also means, and this is the pertinent point really, which re-emphasises that we should take into account all the policies in NPF4, and that pertinent point made in NPF4 on page 7 is re-emphasised, and it says this means ensuring the right development happens in the right place, and that was a point that was made by HES also. Thank you.
Okay, thank you very much. I'm going to move on to the next policy, which I'm interested in hearing on, which is policy 14, design, quality and place. I've picked that up because I think that was covered in the Hofwig policy submission. I'd like to hear parties' views on whether policy 14 is relevant to consideration of this proposal, and if so, is there evidence before the inquiry in relation to the 6 qualities of successful places, particularly in relation to amenity and climate resilience? And I'll start with the applicant, please.
I'm coming in on this one. No, we don't believe that policy is relevant to the development before you. It comes in the heading of NPF, section of NPF4 about livable places, as opposed to the energy policies and others which come under sustainable places. It's headed design, quality and place. Talks about taking it as a policy intent, taking a design-led approach, applying the place principle, policy outcomes, quality spaces, places, spaces and environments. And if you look at policy 14 itself, it is so explicitly geared to dealing with new building development that although using a wide imagination you can apply any policy to any development, this one really does not apply to wind energy development. It cannot be said to do so. You asked the question if it is relevant, is there evidence? I'm going to push back on that and simply say it'd be quite inappropriate to apply those 6 qualities of a successful place to a wind farm when they are so clearly geared to new building development in settlements. That's all I want to say. Thank you.
Thank you. Does the council have a view on this?
To keep it short, it's not a policy that we would normally apply to energy type developments, largely for the reasons already given.
And I come to halfway to it, Ms McLean.
I'm speaking on
Ms.
behalf
Patterson.
of Banbury Community Council. We wrote a local place plan last year, and our vision from the community, the message was very clear. We want Banbury to be a sustainable, nature-based, attractive place to live and work, and we believe that this wind farm is entirely out of character with that vision.
Thank you. I think we've all agreed that all the policies in MPF4 should be considered and read as a whole. And I actually do think that policy 14 is relevant to the consideration of this proposal. Not least, policy 14 requires a pleasant place, and some of the criteria there relate to some of the issues that we've actually talked about in terms of amenity and protection of amenity. And I can see that the agreed statement from Angus Council and the applicant has actually identified that there are detrimental impacts in relation to residential amenity that has been agreed. So therefore, I think policy 14 applies in relation to that issue of amenity. Annex D of MPF4 provides further supplementary description of these 6 qualities. And again, if we looked at pleasant places, the definition includes protection from the elements to create attractive and welcoming surroundings, including provision for shade and shelter, which probably isn't applicable, that particular element. But it also goes on to say mitigating against noise, air, light pollution and other features, as well as ensuring climate resilience. And I think that's the first time that that crops up within MPF4, is in terms of that reference to the requirement for climate resilience. It's actually really cited in policy 14 and Annex D.
And I'll stay with Ms McLean, but I was just going to bring you on to the last question I've got, which is whether those provisions, those considerations you're talking about, amenity, etc., are they not already covered in the matters listed in policy 11 as well?
Many of those elements are probably covered in policy 11. However, that's not to say that issues cannot be covered in more than one policy, and it would be totally appropriate if there was a particular issue of concern, for example, amenity, to reference several policies, including policy 14 as well. That would be my view.
Well, I'll just come back briefly on that. Yeah, you can make any policy fit if it contains certain words, but policy 14 is so clearly not geared to wind energy development. And if you look at Annex D to MPF4, which is referenced in policy 14 as giving more information on the qualities of successful place, that really underlines that what's being talked about is building development within settlements and nothing to do with wind energy development. Thank you.
Well, if localised development extends as far as the applicants wanted to extend, then that's a place which needs to be successful. And the language of I know my own friend doesn't like it, but the language of policy 14 is pretty clear about livable places.
I don't think that needs
Very
an answer.
difficult to ignore. I understand what you're saying, and I understand why you don't like the policy, but it's pretty clear. It doesn't say exclude industrial development, for example.
Okay, I'll just record the difference in views there. And I think what you're essentially saying is that it's a policy that can be juxtaposed with policy 11, as we were talking about policy 4 and policy 7. You feel that's the same, and others disagree.
With respect, the word juxtaposed,
Maybe that's the wrong word.
I'm quite keen on the proper use of English. The word juxtaposed means opposites. They're not opposites, they're complementary.
I meant considered alongside. We're going to move on to section 6 because we considered HEPS and managing change guidance yesterday. Section 6 on the local development plan, local planning policy and guidance. We've already considered the wealth building strategy. So the only question I've got on the interpretation of LDP policies is whether LDP policy HE1 is compatible with NPF4 policy 7. And I'll start with the applicant.
Thanks, that's me, ma'am, that's me again. There are two parts to HE1 which are relevant here. There's HE11, which I say is not compatible with 7H2, since it simply says would have an adverse impact on character, integrity and setting. We will resist development but have an adverse impact. That means any adverse impact on character, integrity and setting of listed buildings or church monuments. If adverse impact is unavoidable, it should be minimised and justified. But then you have policy HE15, which is compatible with 7H, a development on nationally or locally important monuments or archaeological sites, or having an adverse impact on the integrity of their setting will only be allowed if there are exceptional circumstances. That's clearly compatible. And there's some confusion, I think, here between 1.1 and 1.5. 1.5 is okay, 1.1 is not.
Thank you very much. At the council.
Thank you, ma'am. In relation to HE11, I think the wording is inconsistent. I'm not sure I would go as far as describing it as completely incompatible. Resist is different to refuse, and I would perhaps suggest that resisting development could be akin to seeking to minimise the effect, but I would caveat that by saying that is not the primary part of the policy which we would utilise in relation to this development. The pertinent point in this policy is HE 1.5, which deals specifically with scheduled monuments, and I think that we are largely in agreement that there isn't incompatibility in relation to that.
Thank you. Do Hez have a view on this note? And Huthwig? No. Okay, and I did have a supplementary question about that, on if it's not, would the two policies indicate different outcomes? But it sounds like not, but you can just confirm that. Okay, so that's all of the specific policies that I've got questions on. The next section, section 7, relates to where there are policy gaps, where there are issues under discussion which there isn't a specific policy that relates to it. And I've given two examples here. One is fire risk, particularly in relation to a BESS, and the other is infrasound. So I will start with the applicant, please. You can either take one at a time or both. I'll let you decide.
Thank you, ma'am. I think firstly, in terms of battery storage, that is a technology that's referenced in Policy 11 as one that is to be encouraged, facilitated and supported. So there is a policy reference to battery storage. In terms of fire risk, the applicant's position is that that is not material planning consideration to be taken into account. There's a number of decisions that have been lodged to the inquiry. One is, just to give you the two. One is Lochfergus Solar and Battery Storage, which is document 013.044, and the other helpful one is the Shetland Battery Development, which is reference 013.043. So in Shetland, for example, it's paragraph 52. It's quite a short sentence from ministers. They state, ministers recognise the importance of fire safety and note that the company will be required to comply with various laws and regulations on fire safety. Fire precautions and matters relating to health and safety are covered by other legislation, are regulated by the Health and Safety Executive, and such considerations are not material to the application. And in the Lochfergus decision, paragraph 70, the ministers state the carrying out of a fire risk assessment, the implementation of any practical measures to ensure safety and creation of a plan to deal with any emergencies, a legal duty of responsible persons under Scottish fire safety legislation, and so on. And they go on to state that any condition relating to such matters would not meet the 6 tests as set out in Circular 498. So we fully understand that fire risk and safety is a concern, but the matters are covered by other regulations. I would also add that the battery systems, I certainly deal with a number around the country, have done for a number of years, and the technology has inbuilt detection and suppression systems. It's automated, very robust containment systems, and applicants do progress their own emergency response planning in line with their obligations under other legislation. So the matter, I would say, is fully covered, and the approach here, I would say, is to be consistent with the approach that the Scottish ministers have taken in other Section 36 decisions. Thank you.
A question I had on the two decisions that you'd lodged. It was just that I'd observed in those cases, I think that Scottish Fire and Rescue had been amongst the consultees at the outset of those applications. And in one case, they hadn't responded, and one they'd responded just to say they didn't have any objections. So I don't know if you know on the top of the head, but off the top of your head, but I was just going to check whether they'd been a consultee in this case and whether they'd responded.
I'll let others answer if there has been any contact, but certainly my experience is that it's a rather mixed picture with applications. Some planning authorities do consult, some don't. Mr Hewitt can perhaps just tell us a bit about Aberdeenshire's approach, but certainly other authorities don't, and just take a straight position that it's not material for the planning authority because there generally isn't the expertise amongst planning officers to deal with fire matters. And we've actually found that the fire service, their capacity varies in terms of ability to respond to planning applications. Again, they don't have development management teams, hence the reliance is on other legislation and compliance with them.
Come on to the council on this thing.
Thank you, ma'am. The council's position on fire risk and the materiality has been, I suppose, developed over a number of years. We've had quite a volume of these kinds of applications. We don't view fire risk as being material to the planning process. There's a general lack of guidance or policy in respect to this, which means there is no robust test for us to apply to the issue. We are aware of the National Fire Chiefs Council guidance on BESS, which we encourage developers to adhere to, and we do tend to raise that at an early stage at pre-application advice, although it wouldn't have been produced at the time that the Hill of Fare proposal was being initially put forward. Where there is slight materiality in issues of fire risk in the planning system can be in matters of layout, siting and design, and accessing the site, because those are things which will require planning permission in and of themselves, but that would probably be as far as we would consider the matter of fire risk. In referencing the National Fire Chiefs Council guidance, it is just that, guidance. It is not a substitute for policy, which is why we cannot make a decision based purely against that. To pick up on Mr Bell's point, with regard to consultations, Aberdeenshire Council does not consult with the fire service on best proposals. There isn't an arrangement in place to consult, and again, as I understand it, resourcing implications for various organisations can constrain that. However, as a council, given that this is an Electricity Act application, we would have expected the Energy Consents Unit to carry out that consultation, as the fire service is another external body. In terms of conditioning matters of fire safety, generally, again, we would limit this to matters of layout, siting and design. We would not seek to attach things such as contingency planning, emergency planning, because as a planning authority, simply put, that's out with our competence to sign off and agree those documents. And they are covered, as I understand it, by other regimes.
Okay, thank you very much. And Hoffwig.
Fiona Baker, sitting to my right, as you know, represents one of the community councils. They lodged 2 documents which your case officers accepted. Sorry, I don't know the numbers, but you might know the numbers, do you? No. Anyway, what do you want to say about this?
So the 2 decision letters that I submitted relate to 2 BESS facilities, one Braxness and Innerwick and one Home Quarry. These determination letters were made in July 2025, so they're both very recent. In both of those determinations, the Scottish Government has inserted a condition into the design condition, a requirement that that the applicant demonstrates there is adequate fire water on site and that there is sufficient access for emergency services before development commences. I would say that in the case of Hill of Fare BESS, there is currently in the application no provision for fire water at all, and they haven't addressed the issue of access for emergency services. And as far as I'm aware, Scottish Fire and Rescue weren't consulted on the application. Thank you.
Thank you, and I've accepted those 2 documents. I just saw last night they'd come in. That's my email access, not your fault. So sorry, I'll come back to you, in a second. I was just checking you've received those. I think the case officers circulated them.
Yes, we did. I think that approach is consistent with what the council is saying, that there's a planning condition that deals with the detail of compounds, including access and provision of water, which would be supplied to that location in any event. So that fits with the approach to be taken to conditions.
Okay, Mr. Campbell.
Mrs. Patterson, I think, has got something to add to that.
Yes, I was just focusing on your question. What are the implications of these gaps in policy for the assessment of this proposal? And I would highlight that really what needs to be assessed is the risks that the development poses. One of them is a fire in the BESS, other infrasound, but it's not clear what other risk assessment has been made, and more specifically, what mitigations have been identified. For example, the fire, water, access, and so on. So it's really, in any large development, there should be very clear risks assessed, particularly on this project that is surrounded by many people, not receptors, people, and what mitigations have been identified in order to manage those risks. That's not a policy thing, I agree, but it certainly should be taken into account in assessing the viability of the project. Thank you.
Thank you. Do you have anything else on this, Mr. Bell, or do you want to come on to infrasound?
Nothing to add, thank you.
We'll come on to infrasound then. Nothing to add on infrasound?
Oh, sorry, infrasound. I misheard that. My colleague.
Mr Brooks will deal with that.
Thank you, ma'am. Yes, we refer you to Technical Appendix 12.2 of the EIAR, which has a section on infrasound. We've also submitted a further written submission on noise, and as part of that, infrasound is addressed, and we refer you to a document that we have linked in that further written submission from the Institute of Acoustics, and it's an Institute of Acoustics statement in respect of wind farm noise assessment, December 2024, which again covers infrasound. And looking at all these documents, we conclude that there is no implication for the assessment of the proposed development in regards to infrasound. Thank you.
Thank you very much. And does the council have comments on this? No, so I'll come to Hoffwig.
If I may, John. I would like to ask, will this development generate sound below 20 hertz?
Are you asking that question to the applicant?
Yes.
Will the development generate sound below 20 hertz?
Yes, which is generally deemed as infrasound.
Okay.
Yeah, I can answer that. It may generate sound below 20 hertz. But again, I would refer to the IOA statement that I mentioned previously that is in our further written submission, and I will read it out for clarity here. So, and I quote from that: "The Institute of Acoustics is aware that there is some information presented at planning inquiries suggesting the potential for physiological health effects from infrasound from wind turbines. It is current advice to Institute of Acoustics members that there is no need to assess infrasound as part of the noise impact assessment process, as the absolute levels are well below those reported to trigger physiological health effects based on peer-reviewed research to date." And that is from December 2024.
I just asked him, is that the evidence of the IOA or is that the evidence of the applicant?
Is that your evidence?
Yes, we have put a link to that Institute of Acoustics document in our further written submission on Matter 1 noise.
John, for me? Yeah. I've only got one more thing to say, ma'am. And it relates to Dr. Sally Hubban's experience where she had to leave her home when the Viking wind farm started.
Right, where is this set out?
This is in the evidence. Yeah. My apologies, it hasn't been submitted.
Okay, I can't take evidence on it. Is there anything else on policy gaps? I've just mentioned the BESS and infrasound as the ones that I spotted. Are there any others I need to cover? Nope. Then I'll move on to other policy interpretation or application matters raised. Have I missed any specific interpretation submissions from the list that we've talked about so far? Don't think so. You don't think so? Okay, that's good. The next section then is the balancing exercise, and I've got 2.5 questions that I set out on this, but I'm happy to take the balancing consideration together and just hear, apart from the matter, we've talked about balancing exercise a bit already. Do parties have any other comments on the balance to be struck in determining this application? And I'll start with Mr. Bell.
Thank you, ma'am. I would just start by briefly referring to the energy policy framework that we covered. Hoffwig's policy witness states at paragraph 5.15 of their hearing statement that, as advised by the Climate Change Committee, the challenge for Scotland is not to create more clean power. Now, yesterday we looked at the latest Climate Change Committee report, which isn't referred to in the Hoffwig evidence, page 12, and it refers to Scotland currently having 15 gigawatts, around about that, and it needs to get to 66 by 2045. So I would say that the position you've been advised by Hoffwig is wrong, and if that is their position on targets and need, then that fundamentally undermines the planning balance that has been struck by Hoffwig. The applicant has set out the accurate, up-to-date energy policy position. As we've discussed, that's not overriding, but it's important to be accurate on it. The other main policy provisions in planning, we've covered that, NPF 4, Policy 1, Policy 11, giving significant weight, and of course Policy 7 is engaged in some detail given the issues at the inquiry. But this is also national development, so these are the main, I would say, policy provisions in play. In terms of the right development in the right place, you know, it's a sort of nebulous concept there, but to apply it in planning terms, I would say one has to look at the policies in NPF 4 and apply them to see if it is the right development in the right place. And of course, reading NPF 4 as a whole. Thank you.
Thank you very much. Who's speaking for Hofwig?
Mr. Chestnut first, Mr. Briggs, I think.
Just in reply to Mr. Bell, 66 gigawatts by 2045 for Scotland. That's an interesting idea, given that Scotland at the moment uses 4 gigawatts. So, on the planning balance, first of all, we don't believe this is the right development in the right place, particularly due to building on peatland. I won't bang on about that, and overbearing visual impacts. The Balancing Act, the applicant consistently overstates the benefits, the carbon savings and the net contribution to greenhouse gas targets, particularly in Scotland. The economic benefits are overstated. There's also less contribution to energy targets due to curtailment, which Mr. Bell passed off yesterday as somebody else's problem. Just on curtailment, it is real and it's not going to go away.
Okay, I've got all this evidence in the writing though, so it's really just the fine points around the balancing.
Yeah, so we certainly believe, ma'am, that you should consider what the development will actually bring in terms of benefits, which isn't necessarily what the applicant says.
And Mr. Briggs?
I wasn't going to add anything to that, I don't think. Yeah. I don't.
Sorry, that's fine. You don't. My mistake.
Thank you. I'd just like to respond to Mr. Bell's comment that our submissions didn't take into account the Climate Change Committee. If you look at Hofwig's compiled objection document 016.018, figure 4.3, we show Scotland's historical emissions as published by the Climate Change Committee. It demonstrates that Scotland has done a fantastic job in reducing emissions from electricity generation. Indeed, the grid is almost decarbonised. Really what we need to do, as Mr. Bell commented yesterday, in order to get to net zero is focus much more on heat from buildings, transport and agriculture. And that's really lifestyle changes which are very difficult to get the population to do. But as far as electricity generation is concerned, we are doing extremely well. In fact, we're almost decarbonised. So this type of, so any new wind farm development has to be in the best place, the best location, the best benefits in order to add more to the net reduction in electricity generation emissions. This particular wind farm is on a greenfield site with special nature, with peat and highly visible to many, many people. And we would submit that you have to look at the overall balance in the context of Scotland and the net zero emissions targets. And this is not the right development in the right place. I think the population as a whole is very worried about climate change. We all are. We are all trying to do something about it in our everyday lives. We support net zero, but we mustn't have things that are quite blatantly damaging the system supported by the government. We really want to make sure that the right things are done in the right place. So it's looking at the overall balance. Thank you.
Thank you. Just the microphone. Thank you. And just for clarification, Mr. Bell, were you talking about a specific Climate Change Commission document? You weren't saying overall they hadn't been referred to?
Yes, this is the May 2025 advice to the Scottish Government on the carbon budgets, and it sets out in more detail for Scotland the balanced pathway that comes from the 7th carbon budget. Sorry to make it complicated, but that was produced to the UK government, and it's page 12 that sets out the figures that I've referred to, and Hoffig is absolutely right. You know, we talked yesterday about electricity is largely decarbonised in Scotland, and it's the, in particular, heating in homes, electric vehicle uptake, and industrial electrification, and including surface transport, which is the difficult bit. But what the Climate Change Committee is saying is that that has to come from more clean power. So, you know, if you were to do a show of hands in here, probably the majority would have gas boilers or oil. They would drive petrol or diesel. You know, what they're saying is that has to change, so that would come through electrification. So we'd have electric heating systems in houses and cars, and that drives that additional production. And that's the calculation the Climate Change Committee has made. To get there, that's what we need in terms of power in Scotland.
And I would advocate that already in the pipeline there is plenty of projects in order to meet that demand. The demand is probably going to double from 4 to 8. Already there's a lot more in the pipeline to meet that demand. Another wind farm isn't going to make a big difference.
May I say something, ma'am? That increase in demand is not going to happen overnight, so there's a question here of timing. And as to whether or not you need this wind farm now, or in 20 years' time, or 15 years' time. Mr. Bell collapses it all into one thing. We need all this now, but that is anything but the case. And yesterday he refused to contemplate more than one future. There is more than one future. It's not necessarily what the climate change or politicians set out. We do not need all of this power all at once.
Okay, thank you very much. And I just wanted to check with Mr. Bell that May 2025 report was before at the inquiry, and see if you had the reference number for it.
I've got document 013.007, just to check with Amy if that's correct.
Yep.
Yep.
Yes. Okay, thank you very much. So that's all the questions that I had on policy.
Do you mind if the council has an input on that question?
I suppose so. Yeah.
It's short, but I do raise the point because I do have a question to ask the applicants through you. In terms of the balancing exercise, Mr. Hewitt set that out at length in his report that led to the objection, and in essence, that sets out how the council say it should be carried out and the conclusions you should reach. The question I have of the applicants is this: there are various target dates met, and I preface my question by accepting that targets are not caps, and that but what is the likelihood of this development contributing to a 2030 target? Because it's been submitted at other wind farm inquiries that in the last couple of years, that unless that the window for meeting the 2030 target has in fact closed. But you've alluded to the timescales for decisions, not your report, but decisions. And through you, we'd like to know what Mr. Bell's submission is on that, so that we can make closing submissions on it. Because it will go to wait. Grateful.
Okay, Mr. Bell.
Thank you. The position on grid is that there's considerable grid reform underway at the moment, so there's no fixed connection date. So it could be after 2030, it could potentially be before 2030. So there's some uncertainty over that. We talked yesterday about the accelerated strategic transmission infrastructure projects that are going ahead, some very close to here. So the whole industry is affected by the uncertainty over grid reform. That's partly why I think within NPF4 we have the grid constraint not being a material matter, as it is constantly changing, but in particular at the moment through the grid reform that is underway. But that is all aimed at Clean Power 2030 to try and get the infrastructure in place to connect as many projects for 2030. But that is not the end. As we know, it's talked about Atlantic Net Zero is 2045, and I think there's quite a helpful diagram in page 9 of my hearing statement. It's a graph extracted from the 7th carbon budget, and it shows the advice from the Climate Change Committee on onshore wind deployment in the balanced pathway. And you can see that there is a steep rise of onshore wind going through 2030 and then extending out to 2045 and then up to 2050. Just sub 40 gigawatts of capacity is hoped for. So 2030 is a milestone, but the requirement for onshore wind will go beyond that.
That answer your question?
Yeah, it does. I'm grateful, Mr. Bell, what he said, and indeed what he hasn't submitted. It makes the position clear, and we can make closing submissions on that.
Can I just ask, is that figure related to just Scotland or the UK?
That graph is the UK position.
Right, I think, I'm not sure Mr. Bell's got his, excuse me ma'am, got his facts straight there, because the Clean Power Plan calls for 29 gigawatts. And you mentioned in the question yesterday regarding the potential deferment of the decision, you referred to the UK onshore wind task force that's going to report next year. And in the scope of that, it has not yet set out the contribution that Scotland will make. And all the focus in that at the moment is on additional wind power in England, having lifted the moratorium on onshore wind in England.
Would you like to respond to that? No?
We've set our position, thank you.
You have your position. Okay. So I don't have any more questions, so we can bring the policy hearing session to a close. We'll move on to the conditions hearing session. Do people have views on wanting a break of any large size before that, or what do you think, Mr. Trinick?
Just 10 minutes would be good.
Okay then, that's fine. We'll come back at about past and start on conditions.